How to tell whether or not you have a Ccma case. Hi, my name is Aslam Moolla and I am a registered attorney. In today's video, we're going to be looking at the different elements that make up a Ccma case. In particular, for unfair dismissal in relation to a misconduct that you're accused of at work. So let's start off with the two main elements: substantive fairness and procedural fairness. Substantive fairness means that the employer has the right reasons in law to dismiss you. Procedural fairness means that the employer has followed the right procedure when dismissing you. What does substantive fairness mean in the context of labor law? It means that the employer has the evidence to back up the charge that they have against you. This evidence can be in the form of witnesses, documents, emails, WhatsApp screenshots, written statements, etc., etc. Procedural fairness means that the employer has followed the requirements for a fair disciplinary inquiry at the workplace. What are some of these requirements? Number one, there should be a notice given to you for a disciplinary hearing. Number two, you must have the charges explained to you in a way that you can easily understand. Number three, you must have at least 48 hours to prepare for your disciplinary hearing. Number four, you should have been given the opportunity to present your case, your side of the story at the disciplinary hearing. And number five, you should have received a written outcome of the disciplinary inquiry together with the reasons for the sanction if it has been given. In other words, if you've been found guilty and dismissed from work, the employer or the chairperson needs to justify why you are found guilty. So in summary, what have we taken from today's video? You have rights in terms of labor law for substantive fairness and procedural fairness. The employer cannot just fire you without the proper evidence and without having followed the proper procedure. If they have not done so, then you might have a case for the Ccma. What can you get at the Ccma? You can get your job back, what's called reinstatement, or you can get compensation, what's called money paid to you for your unfair dismissal. While we're on the topic of reinstatement and compensation, you also need to bear in mind that if you don't properly prepare your case, there's a chance that you could lose. And the reason why most people don't understand that is because they have a false idea that the Ccma is for employees. You couldn't be further away from the truth. The Ccma is actually a forum for labor disputes. In other words, they listen to the employer and the employee and then they come to the decision, a fair decision. They're not there to advocate for your rights or to listen to your side of the story only and punish the employer. Therefore, you must make sure that you're fully prepared for your case. Now, the best way to determine whether or not you have a case is actually to consult with a proper labor lawyer. That's what we specialize in. If you need help in your situation, whether that's going through the evidence, preparing for disciplinary inquiry, getting ready for the Ccma, filling in the Ccma forms, or even going to the labor court, this is what we specialize in. Contact us. The link is below.